In a disclosure made in the Parliament, the Finance Ministry has said that the Enforcement Directorate has filed 911 prosecution complaints in different courts from Jan 2019 to October 2024 under PMLA, which is the Prevention of Money Laundering Act. However, what is really worrying is trial is pending in 257 cases, Divya, and conviction has been secured only in 42 cases.
That's right, 42 cases or under 5% cases out of the 911 cases have reached conviction in the PMLA cases, wherein 99 accused have been sentenced. And as you spoke about those 257 cases, which is about 28% of the cases are yet to go to trial. So this abysmal conviction rate has drawn sharp criticism from the opposition, with Congress leaders, particularly Randeep Singh Surjewala, bringing this up, saying that this is nothing but blatant misuse of central agencies by the BJP. And to get more on this, we have Kapil Madan, advocate of the Supreme Court and a political analyst, joining us. We also have Geeta Bhatt, political analyst, with us. Let's go across to Kapil Madan first. Kapil Madan, when we talk about the conviction rate in the last 5 years being under 5%, with 28% of the cases that haven't even gone to trial, what is the reason for such a delay when it comes to, also in August, it was the Supreme Court that had, asked for a more scientific investigation in order to increase the conviction rate when it comes to PMLA cases. What do you think is needed in order to perhaps, speed up the conviction rate?
Yeah, so, if you look at the scheme of the PMLA Act, how PMLA works is that there has to be a schedule offense, which is known as a predicate offense. And thereafter, on that basis, PMLA offense is registered and is investigated. Now we have judgments of the Supreme Court where the Supreme Court has time and again reiterated that, it's a stringent act. Bail is, very, very difficult because at the stage of bail, the accused need to convince the court that, no prima facie offense is made out. And, despite those stringent provisions, the agency does not show that kind of, alertness during the course of the trial. So maybe it's, about lack of resources. Maybe it's about, lack of training, because what we've seen is once the accused is out on bail, then the trial typically goes in cold storage, and it takes, years and years, to reach, in the advanced stages of the trial. So I think, more resources, better training are required. And of course, the agency should be very meticulous in, making cases, in the sense that we have seen in the past where the court has given very striking observation against the agencies to say that agency have registered the case when, there was no prima facie evidence available with the agency that justified the filing of the case. So in those kind of a situation, the agency should be very meticulous in registering the case. Only those cases which have credible basis and evidence should be registered. And it should not be, being a stringent provision, it should not be registered as a matter of course, and where you do not have sufficient evidence and basis which can, take you towards the conviction in those cases.
Let's also go across to Geeta, but thank you, Mr. Madan, for giving us a perspective on that. Just to talk about the politics of things, Geeta, opposition, have been time and again raising concerns over ED's actions, calling it biased and vendetta-driven, that there is no evidence. So in a way, lack of evidence leading to a low conviction, that's what it looks like. Doesn't this abysmal conviction rate, in a sense, vindicate the stand of the opposition?
Well, you see, as far as the PMLA is concerned, you see, when you are convicting a person, and that is the case even if you look at the courts in the country, there also the conviction rate is always something that is being questioned, because, the whole process of giving the justice takes really a very long time. So while there is always a scope to improvise, but the fact remains that since such cases where, you are trying to convict someone, there is always a possibility to give an opportunity to the person to just to justify that, the accused is to give him a chance or her a chance to come out clean on the case. For example, if I take it as an example of the case of the former minister of the Trinamool Congress, Mr. Partha Chatterjee, who has been convicted in a bribery case during the recruitment which was taken place for the primary teachers in West Bengal. There, the observation of the court is, the prima facie, you are a very corrupt person. Why a bail should be given to you? And he's been there for quite some time. So in such a case, the Supreme Court, the observation of Supreme Court regarding this was that since there are 183 witnesses, who have to be heard in the court, and there are other supplementary, 3 or 4 other supplementary complaints. CBI complaint is also there, that is also. So all this together is something which drags the case for years together. So the politics of it is that the opposition is trying to, put the blame on the government, but it is the whole process that if required, needs to be revised, whether it is in the case of PMLA or whether it is in terms of, the courts in the country, whether it is in the High Court or the Supreme Court or the lower courts.
There are about 106 courts which are dedicated in, dealing with PMLA cases, and yet the conviction rate is so low. And of course, the opposition there bringing up that in the UPA government of 10 years, the cases, there were only 100 odd cases when it came to PMLA, money laundering cases. But here they're saying that the cases are 911, and yet there's so many cases that haven't even gone to trial, and the only number of cases that have actually resulted in a conviction is about 42, which is less than 5%. And given the fact that 99 people have been sentenced in those particular cases over the last 5 years alone. So Kapil Madan, according to you, what kind of changes need to be made to this very draconian kind of system that's in place?
So, you may recall when this PMLA bail twin conditions were being discussed, there was a judgment called Nikesh Tarachan by Justice Rohinton Nariman, which struck down the twin condition. And this government passed a law which revived those conditions. So I think, the law in procedurally should also be fair to the accused and both the sides. We have judgments where the Honorable Supreme Court has time and again, mentioning recording strictures against the department to say wherein the court observed that if you don't have wherewithal to complete the trial in a time-bound manner, then you can't insist that the accused should remain behind bars just because the offense is serious. So I think, I would just reiterate what I said earlier. Agencies should be very meticulous at the time of registration of those cases. Only those cases where the agencies have material information, credible information, evidence, only those cases, should have been registered. Once you have registered those cases, take it to a logical conclusion. What we have seen during the course of these cases is that once the accused is on bail, then the, pace of these matters go very, very slow because agency would name n number of witnesses and, recording their evidence, their cross-examination during the course of the trial takes a lot of time, which basically, end up either you will have, witnesses, evidences not being available during the course of the trial, or, the witnesses may not remember what has happened, or, sometimes the witnesses also turn hostile. So I think the agency should focus on only quality of cases, wherein only those cases where you have sufficient information should have been registered.
Right, and Geeta, coming back to you, of course, you're a political analyst, and time and again the Congress party and several within the opposition had been speaking about how there is a political witch hunt as far as misuse of agencies are concerned. But according to you, what systemic reforms could perhaps help enhance conviction rates in many of these cases? How can the agency perhaps improve coordination between, investigation and prosecution teams? Because, most of the times, politically speaking, it is said that there is lack of evidence, it's botched up and so on. So how do you think there can be better coordination, and what systemic reforms could be brought in?
Well, I think, the judiciary system in our country is such that it always believes in giving, full opportunity to the accused, that the person can put forth his case and is able to, give ample opportunity to the individual to put forth the case so that he can justify that, he is not a culprit in whatever case it may be. But if you look in totality to the whole of the judiciary system, there time and again it is, the number of courts which are there, in terms of the cases that are being, running in the courts, and then the way the whole administration within the judicial system it works. There are many times when people have said that there are too many holidays in between, because of which the cases they get pending, and then just like on a lighter side, like they say, tariq pe tariq. But here I think it is important is that on overall, if we have to talk about, it is not just about ED or there are special courts, but in totality, if a certain revision has to be required, then it is important that for example, the appointment of judges. There are times when we have seen that in terms of coming to a consensus in terms of the collegium and the government, there are various a number of issues which are related to it. So it is important that when we are talking of improvisation and improvement, then it cannot be done in piecemeal. It is a total overhauling of the way the whole process is run in the country that needs to be addressed here.
Right. Kapil Madan, those charged under PMLA often remain incarcerated for a very long period, given the laws are very stringent, the bail provisions in these cases. Bail is denied until proven innocent. Isn't it time to make that significant change? Because that is what we've been hearing in court lately, is that bail is the norm and jail is the exception.
Yes, in fact, when I was speaking earlier, I mentioned this point. There was a judgment called Nikesh Tarachan, wherein the Supreme Court has held that these provisions, providing strictural, insofar as strict provisions of bail was struck down by the court. But what happened was subsequently a law was passed and those strict provisions were revived once again. But now I think law is taking its own course. Now you have judgment, as we had in Manish Sisodia's case, in Arvind Kejriwal's case, wherein the court has noted that if you have no resources to complete the trial in a time-bound manner, that affects Article 21, right to life of the accused who's facing trial, and that also becomes a ground to get bail. So when you pit this, twin condition as contemplated under Section 45 of the PMLA vis-a-vis Article 21 of the Constitution of India, now you have precedents in the case of Manish Sisodia, wherein the court have said that if the trial is taking too long, then accused has a right to get bail, because you can't, keep him in custody and at the same time you don't have material resources to conclude the trial at a significant pace.
What takes, why is it such a long drawn battle when it comes to PMLA cases? What takes them so long in order to reach conviction?
Yes, so in a PMLA case, you will have typically you will see charge sheet will have many thousands of pages, which again procedurally every document needs to be proved in the court. Who has written that document, from where it was seized, who was what is stated in the document needs to be proved by the person who are aware of what was written there. So procedurally, what happens is that, these things takes a lot of time, and the agencies, again, there are several observations where the court has said that the agencies itself does not have resources to conduct the trial in a speedy and a time-bound manner. I will also give one, very important example. In, other countries like US, once the trial begins, the trial, there happens on a day-to-day basis. But again, in terms of judiciary, the workload, the backlog of cases that we have, we hardly see trial taking place on a day-to-day basis once the charges are framed. So I think in matter like this, where you have such stringent provisions for bail, it is incumbent of the prosecution that they should show their bona fide, in the sense that they should be completing the trial in a time-bound manner, and rather they should insist, because the offense is serious, let's have day-to-day trial, so that we reach to the conclusion ASAP. And if the accused is guilty, he will be convicted, and if the case is does not have any merits, he will be acquitted.
Right.
All right, thank you, Mr. Kapil Madan, as well as Geeta Bhatt, for giving us a perspective on this. Certainly, a 5% conviction rate in prevention of money laundering cases is abysmal.